The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Elizabeth Valentin, and thank you for coming to the webinar for Plan for Your Future and Avoid Guardianship. So 2 housekeeping things to begin with. First, I apologize in advance. I'm getting over the flu, so I may sound nasally and also may sneeze from time to time, so forgive me. And secondly, if you guys have any questions, please enter them in the chat box and I will be sure to answer them at the end. Sometimes people will ask questions that I'll address later in the presentation, so just make sure to put it in the chat box and I'll get to them at the end of the presentation. All right, thank you. So first, in order to really talk about sort of planning for the future and how to avoid guardianship, we kind of have to address what a guardianship is and why a guardianship would potentially be needed. So that being said, why would a guardianship be needed? If one is unable to provide for their own personal or financial management with no documents in place, then one would need a guardianship. So for example, God forbid someone falls into a coma, or they have dementia or Alzheimer's and are unable to pay their household bills, pay their rent, pay their mortgage, pay the electricity bill, things of that nature. If they're unable to make certain medical decisions, occasionally that will require a guardianship. If there are social decisions, who visits with that individual, you know, where do they live? Do they move out of state? Do they go to a facility? Those kinds of questions. If a person is unable to answer those questions and make those kinds of decisions for themselves because they lost capacity, a guardianship may be needed. Now, when can you avoid that? If you have what we call advance directives. Advance directives are a healthcare proxy, a power of attorney, living will, and these are documents that I'll talk about later in the presentation, but if you have those documents in place, then arguably you may not need a guardianship. Because when someone has lost capacity and can't make the decisions I just mentioned, and God forbid doesn't have those documents, what happens is a court has to step in and appoint someone to make those decisions for you. If you've signed those documents, and the documents address all the issues that you have that need addressing when you no longer have capacity, then arguably the person who you have appointed to make those decisions can make the decision for you. Sometimes a revocable trust can assist. Now remember, I mentioned a guardianship may be needed if you're unable to make personal decisions or financial, right? Let's say you don't have a power of attorney, but maybe you created a trust at some point in your life. That trust may be able to assist you in avoiding a guardianship. And again, we'll talk about that a little bit more later. But the idea that I want you to understand is that if you were to lose capacity for some unforeseen reason, again, dementia, stroke, traumatic brain injury, any one of those things, and you're no longer able to make decisions for yourself, and you don't otherwise have documents in place to appoint someone to make those kinds of decisions for you, a loved one is going to have to go to a court and ask to be appointed guardian. Sometimes the issue is not that you can't make the decisions at all because you're in a coma, but sometimes you just need assistance. And you can acknowledge that you need some assistance. And there are capacity issues. Someone can then still seek a guardianship and have you consent to that. Another time that a guardianship may be needed, is if someone has reported physical or financial abuse, right? So there's an agency called the Department of Adult Protective Services. And generally how this happens is, you know, there may be someone who lives alone and is having some capacity issues, has the beginning, let's say, of dementia, and is no longer checking their mail. So the mail or the bills are just piling up. And someone steals their mail and gets into their bank accounts, and a neighbor notices this, they can report it to Adult Protective Services, and then Adult Protective Services will step in and sometimes commence a guardianship action in order to assist that individual. So I mentioned the word guardianship as if there's only one, but there are many different types of guardianship. And I want to be clear that what I'm referring to today is what is called an Article 81 guardianship. And Article 81 is the provision in the Statute of Mental Hygiene Law that speaks specifically to this type of guardianship. There are others. This type of guardianship is intended to be the least restrictive form of intervention. So the idea is that if an individual has lost capacity and is unable to make, let's say, 7 of 10 decisions, but can still make the remaining 3 decisions, they should be able to do that. The idea behind this guardianship is to afford the individual the greatest amount of independence. So a lot of times in a guardianship, depending on what the cause of the lack of capacity is, the individual can participate in the proceeding and can express their wishes and say what they want. Now, remember, this is in the context of some loss of capacity. So while the individual can participate in a guardianship proceeding, this is not your ideal scenario, right? The ideal scenario is that you've prepared and you've addressed what your potential concerns might be for the future in what we would call estate planning documents. But you should be aware that this particular type of guardianship does allow for participation by the individual that's claiming or someone's claiming needs a guardian. It's not an all or nothing guardianship. So it's not that someone files a guardianship and says this person is losing capacity because they have dementia and therefore a guardian needs all the powers to make every decision on behalf of this individual. Because it is supposed to be the least restrictive form of intervention, the individual's decision-making capacity comes into play, obviously, and the court needs to investigate what decisions that individual can and cannot make. So for example, if the person has dementia, they may not be at the advanced stages, they may be in the moderate stages. So perhaps they cannot, make certain decisions like paying their bills and so on and so forth, but they can still express wishes and desires so they can participate in the conversation about where they live or who visits with them, those kinds of things. So again, whoever's appointed a guardian is not necessarily going to have the right to make all decisions on behalf of this individual. It's supposed to be tailored to what that individual A needs and B, what they can and cannot address on their own. So the powers are to be limited and tailored to what the person needs. So I mentioned that there are other guardianships, and 2 of the guardianships that are often sort of gone back and forth and confused by individuals is what we call a 17A guardianship. Now, 17A is a whole different statute. It's under the Surrogates Court Procedure Act. And as I mentioned, the one I'm talking about is an Article 81 guardianship under mental hygiene law. Under Article 81, it addresses loss of capacity that has anything to do with things other than developmental disabilities. So developmental and intellectual disabilities are things like Down syndrome, autism, anyone on the spectrum. Those types of issues and disabilities would be addressed, and loss of capacity arguably would be addressed under Article 17A, not Article 81. So if someone had Down syndrome and they needed a guardian, it would be addressed under 17A guardianship, not under an Article 81 guardianship. They operate on completely different premises. They're 2 totally different types of guardianships. They're brought in different courts. They're regulated, as I mentioned, by different statutes. And they have different procedures in place. They have different costs associated with them, and they're handled in very different ways. So as I mentioned, in Article 81 guardianship, the guardianship is tailored to what that individual needs. In a 17A, it's all or nothing. So they are very different, and I only raise that so that you understand the differences in case you hear that someone has lost capacity and needs a 17A. I want you guys to understand that the 17A only applies if the individual has a developmental or intellectual disability. And everything else would fall under Article 81 if addressing loss of capacity issues. So again, as I mentioned, it's for someone with a developmental disability or intellectual disability. Now the one catch is that it has to be diagnosed before the age of 22. If an individual was not diagnosed before the age of 22 and has a developmental or an intellectual disability, then they could arguably go after an Article 81 guardianship. But otherwise, it's going to fall under 17A. As I mentioned, there's no tailoring of powers under 17A, and it's a full guardianship. All the powers are given to the guardian. The other major difference is, and you should be aware of this, is that under an Article 81 guardianship, the one I initially spoke of, in order to be granted guardianship, you simply have to prove to the court that that individual has what we call functional limitations. So say, for example, my father has dementia. He can get in and out of bed, but he doesn't remember to shower. He, has difficulty toileting, things of those nature. I can prove that he needs assistance by discussing what kind of help he needs every day. I don't have to bring medical records. I don't have to put a doctor on the stand. Under a 17A, you actually need proof of the diagnosis of that developmental or intellectual disability. So it's different. It is very different. So just to give you a little more background on sort of why it's so important to do the documents and avoid a guardianship, right? So as I mentioned, a guardianship is to appoint someone to make medical or financial decisions on behalf of someone who no longer has the capacity to do that themselves. In and of itself, it doesn't sound like a horrible thing. But one should know that you're literally removing that individual's rights to make decisions for themselves. That's the first issue. The second issue is that while the court does take into consideration what that individual needs, there are a number of other players involved that have some decision-making capacity along the way that may end up in a result that the individual doesn't want, right? So the individual, the person who's lost capacity, is referred to as the alleged incapacitated person. Occasionally, if the person has some capacity and can participate in the proceeding and maybe even consent to having a guardian, they would be referred to as an alleged person in need of a guardian. Whenever you have a guardianship hearing or a guardianship proceeding, the court will appoint a court evaluator. That person is the eyes and ears of the court. So when someone files for guardianship, they tell the court, this is what I understand to be happening, and this is why my loved one needs a guardian appointed. The court evaluator's job is to go out there and investigate everything the loved one just said. If they claim that that person has dementia and is in a nursing home, the court evaluator has to go out, visit the person in the nursing home, talk to the doctors, talk to the family members, the friends, and confirm that everything the loved one is saying is in fact true. That individual then goes back and does a report and files that report with the court and gives a recommendation as to who he or she thinks the guardian should be. Now, how great that report is, how effective that recommendation is going to be, has everything to do with how thorough the court evaluator is. And unfortunately, sometimes the court evaluators are not as thorough as they can be. And that presents a problem, right? Because then the court is not getting exactly a full picture, and it might be leaving out information that either can prove the person doesn't need a guardian, or that there are other individuals that can serve as guardian other than who the court is entertaining. The court evaluator is supposed to go out, as I mentioned, and interview family members, whoever they're proposing to be the guardian, and anybody else who has an interest in that proceeding. The court will also appoint what's called a court-appointed attorney for the alleged incapacitated person. Now, there are times when the court doesn't appoint an attorney for the alleged incapacitated person, but there are times that it does. And depending on what powers the guardian is seeking, the court may give the individual their own attorney. And that attorney is really just there to represent what the alleged incapacitated person wants and needs to the extent that they can express that. And then there's the guardian. The guardian is who, at the end of the day, the court would appoint to make medical or financial decisions for the individual that we all alleged was incapacitated, and at that point deemed actually incapacitated. So the powers that the guardian has are whatever the powers the court thought was appropriate for that individual to have in order to make decisions on behalf of the incapacitated person. The guardian can be a family member. Courts tend to lean towards family members being the guardian, but it's not necessarily a given that a family member is going to be appointed. Sometimes you have opposing family members, right? So let's say my father needs a guardian. My mother files a guardianship proceeding for her to become the guardian because my father arguably never signed documents before he got dementia. My sister could file her own petition and argue that she should be the guardian and my mother shouldn't be. And I could do the same thing. And now you have three people opposing the other and pointing the fingers and saying, this person shouldn't be the guardian and these are all the reasons why. Now it's up to the court to decide who's most credible, yes, but sometimes what courts do is to err on the side of safety is they'll just appoint an independent person. And there's a list of people that the court has that can serve as guardians on behalf of an individual. So this individual is not a family member. They may not even be a lawyer. It might just be a social worker. And that person could be tasked with making all or some of the life decisions for this particular individual. As I mentioned earlier, the guardian can make financial and/or personal decisions depending on what you're arguing that individual needs. If the person who has no capacity can't make financial decisions, for example, manage their accounts, pay their bills, all those kinds of things, and a guardian, what is called a guardian of the property. A guardian of the property is the person who handles the financial aspects of the guardianship. The guardian of the property has to be bonded, which means they have to get insurance that will sit in place on the off shot that the guardian runs off and steals the money of the incapacitated person. The insurance can pay back in so that the incapacitated person isn't at a loss. But that means that the person has to be able to get bonded, which requires never having filed for bankruptcy, having good credit, maintaining a certain amount of income annually. All those things go into play, right? And sometimes who we would want to make financial decisions for us isn't able to get bonded. Perhaps my sister, who's a stay-at-home mom, who prior to being a stay-at-home mom, worked in the financial district, but no longer does and is now a stay-at-home mom, she won't be able to get bonded if she doesn't have, income, or her credit isn't good, or any one of those reasons. So despite the fact that we have this mechanism of a guardianship to appoint someone to make decisions on behalf of an individual who no longer has capacity, if they never signed the appropriate documents to take care of those issues, while this system is in place, sometimes it doesn't play out exactly how the individual would have wanted. And one of the main ways is that whoever is appointed as guardian is not necessarily who the individual would have wanted. There will be a hearing in a guardianship, and the person who's alleged to be incapacitated should be present at that hearing. Sometimes if they're really not able to participate in the proceeding, for example, they're in a coma, or the dementia is so advanced that they can't recognize who any of the parties are, their appearance could be waived. But for the most part, they need to be at the appearance. And anybody who wants to participate in the guardianship would also be at the hearing. And in theory, the hearing is a great thing. However, sometimes the hearing becomes the vehicle in which all the family sort of dirt, so to speak, is aired out, right? At this hearing, what ends up happening is whoever is alleging that this person is incapacitated and needs a guardian, he or she would have to prove that this person is in fact incapacitated. And based upon that hearing and whatever evidence is presented, the judge would make a determination and decide who would be the guardian on behalf of that individual. The court considers certain things, right, in order to make a decision as to who should be the guardian. First, did the person who's incapacitated ever sign what we call a nomination of guardian? And I'll discuss that in a few minutes. A nomination of guardian is a document where you appoint someone that says, in the event that I need a guardian, this is the individual I would have wanted. Now, the court will take that into consideration if such a nomination was made, but then again, we'll look at what the factors are that are needed for an individual to serve as guardian. So if it's guardian of the property, can they get bonded, as I mentioned a few minutes ago? Second, the court will look at any recommendation that the incapacitated person makes during the proceeding. Remember that just because someone is incapacitated in the sense that they can't pay their bills and manage their finances doesn't necessarily mean that the individual can't express wishes or desires. So they can express who they would like to serve in that capacity, and the court will take that into consideration. Sometimes the court won't take that into consideration if it appears to be a conflict of interest for some reason, right? And as I mentioned, family members are generally preferred, but mental hygiene law, the statute itself, does not give them any preferential status. So to the extent that the court thinks an independent person or a non-family member is more suitable for a number of different reasons, the court has the right to appoint such an individual. So I mentioned earlier that a guardian could be appointed or sought if there were financial or medical decisions to be made, right? The guardian of the person would handle all of the medical and social decision-making that needed to be made on behalf of an individual. So that would include major medical decision-making, except for end-of-life decisions. Those things would require further court order. It would provide personal care and assistance, control over their social environment, so who visits with them, where do they live, things of that nature, whether or not the individual can travel and to where they can travel. access to and release of medical records, education, applying for benefits, government or private, and again, choosing where they live. Those are big ones that come up in guardianship. So the guardian of the person is able to make all of those decisions, or some of those decisions, depending on what the court thought was appropriate to grant that individual. Now again, when we talk about ways to avoid this guardianship, we'll talk about which documents would apply to avoid a guardian of the person. Guardian of the property, and I mentioned this earlier, is the role that allows a guardian to control whatever the finances are of the individual who we're alleging is incapacitated. Now, remember, that individual has to get bonded to ensure that, if there's any mishandling of the funds, that the incapacitated person is not harmed in any way. Now, the guardian of the person and the guardian of the property are two separate roles. However, they can be done by one person, or they can be done by two separate people, or even 4 people, 2 in each role. But the roles themselves are very separate. Sometimes a court will appoint a guardian of person and not a guardian of the property, or the other way around. So I mentioned that the guardian of the property needs to get bonded. Well, both the guardian of the property and the guardian of the person has to take a training course. So the court will direct that that individual take a training course and provide the certificate showing that they took the training course so that they understand what their responsibilities are. The guardian of the person and property will also have to file annual reports. So every year in May, they will have to file a report with the court that shows what they've done with the incapacitated person for that year. So from a guardian of the person perspective, that individual would show what doctor's appointments went to, where did they, where are they living, what medicines they're taking, if anything changed from the last year, who's visiting with them, where do they live, have they moved, any of those kinds of things. From a guardian of the property perspective, the guardian of the property would account for all the assets and income, what came in, what went out, and why. Avoiding a guardianship. So as I mentioned, all of that is just kind of a brief explanation of what guardianship is and how it works. Now again, it doesn't sound horrible, right? And it is in place on the off shot that an individual doesn't do what we're about to talk about. But it should be understood that a guardianship does have pitfalls, right? And that it should be avoided to the extent that one can avoid it. For one, the decision of who can make decisions on your behalf is left to someone other than you. Sometimes, as I mentioned, the incapacitated person can express wish and desire by the time the guardianship hearing is had, and the court generally takes that into consideration and for the most part will appoint whomever the individual wishes or desires. But in many instances, it's simply not possible. But if one does the documents that are required to address those issues if one loses capacity, you can potentially avoid a guardianship. So let's talk about how you can do that. I mentioned earlier that you can avoid it if you have advance directives. So advance directives are a power of attorney statutory gift rider, a healthcare proxy. So a power of attorney, for those of you that are not aware, is the document that allows you to appoint someone to make financial decisions for you. New York has a statutory form, and that's relatively new in the sense that in 2009 and then again in 2010, New York introduced a statutory form. Before that, everybody had their own form. Our office had a particular power of attorney form. The Blumberg Company had one that they would sell in stationery stores. Other law firms had theirs. They didn't all necessarily look alike. They didn't all necessarily have the same powers. But as of 2009, we now have a statutory form. And as of that date going forward, all New York powers of attorneys have to look the same. There's only one section in the power of attorney where an individual can make what we call modifications to it and add other powers if they wanted. And in that particular section is the only place. Otherwise, they all look the same. One of the main changes after 2009 and 10 was that the power of attorney was capped at only being able to gift up to $500 a year in gifts in total. Because there are individuals that want to be able to make gifts larger than $500 in total per year, there's also a statutory gift rider which allows the individual to sign this separate document that allows their agent to make further gifts. The healthcare proxy, as I mentioned earlier, is the document that allows you to appoint someone to make medical decisions for you if you can't. So the power of attorney handles financial and the healthcare proxy handles medical. Similar to how a guardian of the property handles the finances and guardian of the person handles the medical. Family Healthcare Decisions Act. So I just want to briefly mention this. So New York has a statute that says if you didn't sign a healthcare proxy and you lost capacity. So for argument's sake, I never sign a healthcare proxy and I fall into a coma and I'm unable to make any medical decisions. This statute kicks in and says that there are individuals that can make decisions on my behalf, which avoids a guardianship to a certain degree, right? So if I don't sign a healthcare proxy and I've lost capacity and a medical decision needs to be made, arguably under Family Healthcare Decision Act, certain individuals can step up and make that decision for me. Now, the list of people who can make that decision kind of mirrors the list of people who would inherit your estate if you died without a will. The first person is a court-appointed guardian, then it's your spouse, then children, parents, siblings, and so on. It keeps going down. And the last person is a friend who could establish that they had a relationship with you and knew what you wanted in terms of medical care. So more about the power of attorney. As I mentioned, New York has a statutory form. Now, under our statutory form, not only does the person who's what we call the principal, the person who's actually granting the power, have to sign the power of attorney, but the agent, the person that we're appointing to carry out our wishes, must also sign the power of attorney before it becomes effective. The power of attorney is what we call durable, which means that while you have capacity when you sign it, it is still effective after you've lost capacity. Now, one thing you should know about the power of attorney and how it differs from, say, a healthcare proxy, aside from the fact that one is for finances and one is for medical. A power of attorney, the New York statutory form, if I sign it today and I appoint, say, my sister to be my agent, and she signs it, it is valid. My sister can act as my agent. It does not require that I lose capacity in order for it to become effective. It is effective the moment my agent signs off on it. That's important to understand. Now, while attorneys may say if you don't trust your agent to not do the wrong thing, then perhaps you should rethink appointing your agent. But in any event, some people are not comfortable with that, and they want to convert the power of attorney into what we call a springing power of attorney, meaning the power of attorney itself doesn't spring into action. It doesn't become effective until a particular event, and that event could be your loss of capacity. How you would prove that is by a doctor doing an affidavit. So while the statutory form is not a springing power of attorney, you can make the New York power of attorney into one that is springing. As I mentioned, there's one section where changes can be made, and in that section, it can be converted into a springing power of attorney. But you should know that the statutory form, as I mentioned, on its own is not a springing power of attorney. The power of attorney in terms of documents, so all legal documents don't require the same level of capacity. And capacity is your ability to read the document or be read the document and understand what it means and its effects, right? So a power of attorney requires a very high threshold of capacity at the time that you sign it. So the power of attorney is one of those things that you're not going to sign when you barely understand what's going on. It's akin to a contract. You need to understand what the ramifications are of you appointing someone as your agent to manage your affairs. It has a high threshold of capacity needed. The agent, remember, the principal is the person who gives the power away, and the agent is the person who you're appointing to stand in your shoes and make those decisions for you. That individual is what we call a fiduciary. They have accountability. When they sign that power of attorney form, one of the reasons why it was important for the agent to sign the form is on the form itself, it even tells them that they should seek an attorney. They're unsure of what their responsibilities are under there. There is accountability of the agent. If the agent does something, you can take it a step further to avoid abuse. The new power of attorney by Neal, again, 2009, 2010, one of the things that it allows you to do is to appoint a monitor. So right on the document, you can appoint someone whose sole job is to oversee what your agent is doing. The monitor doesn't make any actual decisions. They just make sure that the agent is doing their job. They can request records, so they can request bank statements, they can request, sort of justifications for things that have been done, and they can start a lawsuit on your behalf against the agent if need be. And we'll talk about trust in a little bit, but perhaps also creating a revocable trust can avoid the abuse of an agent. So who should serve as your agent? This question is really a very personal question. Now, the overarching thing that you should know is that a power of attorney is important for you to have, because if you've lost capacity, as I mentioned, there's Family Healthcare Decision Acts, so that if a healthcare proxy isn't signed, someone can make medical decisions for you. If you didn't sign it without a guardianship, there is no such statute for financial decision making. So if you don't sign a power of attorney and you've lost capacity, you're going to need a guardianship in order for someone to do the most basic of things like pay your bills. So who should serve as your agent? It can be anybody you trust. Your spouse, your children, if they're of the age of majority, siblings, parents, anyone that you trust that would do the right thing. You can have more than one person serve as your agent at a time. Now, I will tell you that too many cooks in the kitchen sometimes is problematic. It's really not recommended that you do more than 2 people at a time, but you can. You can also specify how your agents work together. Do you want them to be required to always work together, or do you want to allow them to work separately? In which case, sometimes the agents don't both live in the same state. So let's say I appoint my mother and my sister. My sister lives in Georgia, my mother lives in New York. If I require that they act together all the time and some bank transaction needs to occur, will my sister have to come up from Georgia to handle it? So you can designate how you want your agents to act. You can compensate your agent. So to the extent that you want to pay them, the power of attorney allows you to do that. You can set an hourly rate, but you also don't have to. Gift giving. So I mentioned at the beginning that a power of attorney, the gifting, your ability to, on behalf of the principal, give money away to another individual, is capped at $500 in total per year. To the extent that you want to expand that amount, you can sign the separate gift rider. You would have to initial on the power of attorney itself that you're also going to sign off on the gift rider. So, financial institution acceptance. So a lot of times what will happen is individuals will sign a power of attorney and it's valid, and then the financial institution gives them a hard time in accepting it and placing it on the file. So if I appoint my sister as my agent, and one of the powers I give her is banking transactions, I want to make sure that Chase allows her to get in and out of my bank. So sometimes we'll tell clients, you know what, we're going to sign the power of attorney because the powers granted under the power of attorney are expansive, right? I address things like veterans benefits and human resources issues and Medicaid and things like that, but I'm also going to sign the Chase bank account power of attorney so that I know that Chase is not going to give my agent a hard time, and sort of file them together. So you should know that that happens as well. With respect to snowbirds, people that are living in 2 different states, if you're going to be, let's say, in Florida during the winter and New York in the summer, the documents, New York's form is a statutory state form. That's New York's form. Florida's form may look nothing like ours. The requirement for execution might be completely different than ours, right? You may want to do one in New York and one in Florida so that if anything comes up, you're not losing any time getting Florida to understand and accept the New York form. They would have their own form, they're familiar with it, and you can get them to accept it sooner. Back to the statutory gift rider. So as I mentioned, if you want to have the ability to let your agent gift more than $500 at a time per year, per individual, you can sign this statutory gift rider. It is a separate form, but it must be signed at the same time as the power of attorney form itself. It cannot be signed 3 days later or 1 week later. They must be done together. This is the only way to allow an agent to gift more than $500. It also lets you detail to whom those gifts can be made and how much more than $500. Now, the power of a power of attorney, or the effectiveness, I should say, of the power of attorney has everything to do with what powers you give your agent. So when one says, if you have a power of attorney, you can avoid a guardianship, that statement is in part true, but in part not so true, right? If I sign a power of attorney because I'm gonna go to I have a closing on an apartment, and I want to allow my husband to sign off on both of our ends, and I sign that, and in that power of attorney, the only power I give him is the ability to attend our closing and deal with real estate transactions. And on that same day, God forbid, I get into a car accident and I fall into a coma. That power of attorney does not give him the right to get in and out of any of my individual accounts. It only allowed him to go to that closing and address real estate transactions, which means that if he wants to apply for Social Security disability on my behalf, if he wants to get in and out of my retirement account, if he wants to get into that savings or checking account that is just in my name alone, he's going to have to do a guardianship. So again, how effective the power of attorney is has everything to do with what powers you give your agent. Now, as a general statement, the more powers the better, because we don't know what the agent's going to need when and if that power of attorney is required. And there are a number of different reasons why people are uncomfortable granting all powers to an individual, depending on the stage of their life, right? What a power of attorney means to someone who's 30 versus 40 versus 70 is very different. However, that being said, remember that in this context, when we're talking about avoiding a guardianship, that power of attorney is only going to be as good as the amount of powers that you give the individual. Healthcare decision making. So this is where we get into the healthcare proxy. And remember that the guardian of the person under a guardianship is has the same kind of powers that a healthcare proxy would. So a healthcare proxy is where you appoint someone to make medical decisions for you if you can't. Now, unlike the power of attorney, aside from it being addressing medical decision making, here there is a requirement that there's proof that you don't have capacity before the agent can step up and make those medical decisions for you. So a physician must make a determination that you can no longer make decisions for yourself before the healthcare proxy can step up and make those decisions. In a healthcare proxy, you can appoint as many people as you want, but only one person at a time in New York, right? They have to be of the age of majority, and it can be anybody you want. Again, your spouse, your children, parents, friends, religious leaders or spiritual leaders that you may have, you can do that as well. You can, however, you can only appoint one person at a time. A healthcare proxy, New York has its own form as well, and you can get that online. But if you look at a healthcare proxy, it does allow you to talk about, gives you 2 lines, but it does allow you to talk about what your medical wishes are. Now, most people have very strong feelings about end of life issues, or to the extent that they are religious issues that intersect with medical, procedures or treatments. People will have very strong feelings about that and will generally appoint someone that is aware of that. However, sometimes the individual is not aware, and it's important to sort of communicate that information to your agent. On the healthcare proxy, it gives you, like I said, a small window where you can put in that information. However, what most people will do is just say, my agent knows my wishes, and then also do what we call a living will. So a living will has nothing to do with your last will and testament, which is what we loosely call a will, right? Your will, where you distribute your assets upon your death. The actual terminology is your last will and testament. A living will is medical instructions. A living will is where you talk about if you have feelings about, let's say, end of life, if you want to be on life support or you do not, if you have, feelings on artificial nutrition and hydration, you can talk about those things in a living will. If you have religious limitations, for example, if you're a Jehovah's Witness and you can't get blood transfusions, things of that nature, those kinds of things you would talk about in a living will. In terms of capacity, I mentioned that for a power of attorney, you need a very high threshold of capacity in order to execute that document. For a healthcare proxy, the capacity needed is quite low. So one could be on their way to surgery and sign a healthcare proxy while in pain, right? So it's different from a power of attorney in the level of capacity needed. Your agents, same thought process with the power of attorney. You can appoint whomever you want. You just want to think about who you're going to appoint and whether or not they're going to do right by you. One difference, though, however, here you're talking about not just who's going to do right by you, but who's going to do what you actually want. So you want to talk to your agent about what your wishes are. You want to make sure that that person is going to follow your wishes, you know. And I always tell the same story, which is I got married later in life, and before getting married, I appointed my mother as my healthcare proxy. And then my father got ill, and we needed to make end-of-life decisions. And it was actually the first time that I was having the conversation with my mother about end-of-life decision-making. And I was quite young, so it never occurred to me to have that conversation with my mother. But with my father being ill, we needed to have the conversation. And in having the conversation was the first time she acknowledged to me that although I didn't want to prolong my life unnecessarily, if I was found to be in a vegetative state, she made it very clear that she would do so. She would do what she thought was appropriate and not so much what I wanted. And, at that point, I realized while my mother loves me to death and would always do what she thinks is best for me, she's not necessarily going to be the person who follows what I want. And when you're talking about making medical decision-making on behalf of someone, that's what you're really looking for. So you want to make sure that you appoint the right person as your agent for those reasons, right? You want to think about second marriage issues. If you have children from a first marriage and you appoint your spouse from the second marriage, you want to consider if they're not all on board and you didn't have this conversation without a healthcare proxy in place, what is that going to look like if a decision needs to be made? Without a living will in place, will it create more problems than less problems? Is cost a factor? What's your quality of life? What's your desire for quality of life? All those things should be talked about with who you're thinking of appointing as your agent and should go into the thought process in selecting your appropriate agent. Now, remember, to the extent that you don't sign a healthcare proxy and you've lost capacity, Family Healthcare Decision Act does allow someone else to step up and make that decision on your behalf. However, that should not be the default. One should not avoid signing a healthcare proxy because they assume that the Family Healthcare Decision Act, will step in and sort of ensure that someone is appointed. These decisions are very personal, and they're all about sort of maintaining some sense of control now while you're not able to exhibit that control, right? And it's quite possible that the people on the Family Healthcare Decision Act are not the people that you would have wanted, or the very people that are not going to sort of execute the decisions you want. I had a client once who came in to do documents and had a various number of issues as to why she didn't want to sign a healthcare proxy, and a lot of it had to do with sort of superstition about what that would mean for pending illness and things of that nature. But nevertheless, she had only one living relative, and that was a sister who she despised. They had absolutely no relationship, and not even just no relationship. She really wanted nothing to do with her. And we had to have the conversation that without you signing a healthcare proxy, she could stand to make those decisions for you. And if she came forward and wanted to make those decisions, there could be issues. And so, we had that conversation, but it's important to remember that you should not avoid signing a healthcare proxy simply because you think the Family Healthcare Decision Act is going to kick in and take care of that. Also, with respect to the living will allows you to actually talk about what you would want to see happen if you found yourself in certain scenarios. Without signing the healthcare proxy and the living will, that conversation would never come up necessarily without you spurring it on first. So it's important to think about these things. Again, we mentioned that, New York has a form, a statutory form that you can, or I should say a standard form that you can use that allows you to appoint that individual. We talked about the Family Healthcare Decision Act and the fact that someone else can step in and make that decision for you to the extent that you can't and do not have a healthcare proxy in place. So trust. So as I mentioned, the power of attorney, if one signed it and had the sufficient powers needed, if one lost capacity, you could avoid a guardianship, right? A healthcare proxy and a living will, to the extent that you sign those, could avoid a guardianship from a medical decision-making perspective. Sometimes the power of attorney doesn't grant enough powers, right? Or sometimes the individual is concerned that they don't want to give all the powers. And so they know that if they lose capacity and these other powers that they were unwilling to give their agent are needed, that there could be the potential for a guardianship. What can be done under those circumstances is one could create what's called a revocable trust. A revocable trust is exactly that. It's revocable. So you can terminate it at any point. You can amend it if you want it at any point through your life. The way a revocable trust works is you create this trust, and a trust is a fictional entity, similar to a corporation where it exists but it doesn't exist, right? If you envision a box and the trust is the box, you can put all of your assets inside that box. And you appoint a trustee to manage the box. And you could be the initial trustee. So while I'm alive and healthy, I manage my box. To the extent that I lose capacity, I could have someone already appointed in place that if I can't manage the box anymore, that person kicks in and manages the box for me. So long as I'm healthy and able, I'm managing that entire box. I lose capacity, this other individual manages it. Now, that allows for a seamless transition, right, of me to someone else of managing my affairs, which I know won't happen until I've actually lost capacity. I also know the court doesn't have to get involved in any way because I've already, in the trust document, appointed who should make those decisions about the trust once I've lost capacity. It also avoids probate. So upon my death, whatever's in that box will get distributed exactly how I dictated it in the trust document itself. Now, the beauty of the revocable trust is only that, or is that whatever is in there is going to be managed by me and then someone else when I've lost capacity. But the catch is, all of my assets have to be in that box. If half of them are in and half of them are out, and my power of attorney doesn't give all powers, the half that's outside of the trust still might need a guardianship to manage. So the revocable trust is a way, in conjunction with the power of attorney, to sort of avoid a guardianship. However, you know, there are limitations to it, one of which is if you don't put everything you own in that trust, you might still find yourself needing a guardianship for the assets outside of the trust. And that is it. So if anyone has any questions, I ask that you please put them in the chat box so that I can answer them. If not, thank you very much. So I've been told there are no questions. So thank you for coming, and I hope this was able to help you avoid guardianship in the future.